I'd like to call to order the St. Tammany Parish Board of Adjustments meeting for October the 7th.
Their speaker thing is up.
Okay.
You got it? Okay. Are y'all able to? Okay, we're good. Okay, excuse me. All right, I would like to ask Ms. Lambert to call roll.
Mrs. Thomas,
Present.
Mr. Daly, Mr. Blosh,
Here.
Mr. Glockner, Mrs. Wendell,
Here.
Mr. Sanders, Mr. Horn. Madam Chairman, we have a quorum.
Thank you. Since we do not have our alternates today, I want to explain to the people that are presenting cases that there are 4 committee members here, which makes a quorum. However, if it will have to be every member of the committee will have to agree on the decision to accept the variance or to reject the variance before we can go forward. So that gives you an opportunity to request a postponement until next month, assuming that we would have 1 extra person here so that the vote would be, you would have a chance, if you're not wanting to take the chance on all 4 of us agreeing and voting to support. 3 of us could agree, and 1 of us could say we don't agree, and it is still, then we would have to go with it's not approved. So I just want to explain that prior to, Mr. Horn's here, saved by Mr. Horn. Sanders, I'm sorry. I didn't have on my glasses. All right. We're going to step back from that. We now have Mr. Sanders here, so we'll proceed
You
with
would like to appoint Mr. Sanders
an
officially
appointment of
as a voting.
Mr. Sanders to be a voting member of today's Board of Adjustments meeting. All right. I'd like to make a couple of announcements. Please silence all of your phones and also any devices that you have. If you do not agree with the decision that this board makes, you have the opportunity to file an appeal with the Judicial 22nd Court. We have speaker cards available on either side if you would like to stand up and talk about a case. Public speaking is 5 minutes each side and 3 minutes for any additional comments. And then we would ask that when your case has been presented and decided upon, that you leave the building so that we can continue with the next case. People sometimes talk outside and we can't really hear what's going on in here, so it's a matter of courtesy to you and to us, so we appreciate that. All right, I would ask the board, have you read the minutes from last month's September 2nd meeting? If so, do I have a motion to accept?
Motion. Second.
It's been moved and seconded that we accept the approval of September 2nd meeting minutes. All right, so
Please,
today
We need to vote.
I'm sorry?
Vote on the
Oh, I have to
minutes?
vote, I'm sorry. Never mind. All right, would you all please vote with your screens? And mine's not on. There it is. Okay.
One more. All in favor, motion carries.
Thank you. All right, today we have 2 cases, and the first case is BOA 2025-4368, which is 265 Magnolia Street, Mandeville, Louisiana, Ward 4, District 10. The variance requested is a request by an applicant to reduce the rear yard setback from 25 feet to 5 feet and the side yard setback from 7.5 to 5 feet to allow for an accessory structure to be remodeled into a guest home. I would ask the staff to please read their findings.
The objective of the request is to convert an existing accessory structure into a guest house. Although the structure permitted in 2023 is situated behind the primary residence and complies with the setback requirements applicable to an accessory building, it does not satisfy the setback standards required for a guest house. While no hardship has been identified, the following points merit to be considered. The accessory structure remains under construction. However, initial inspections for drainage and foundation have successfully been completed, and no objection letters have been submitted by adjacent property owners.
All right, I need to speak to council quickly.
I know, that's what I was gonna say. Well, you do have an objection letter now. So can I say that?
No, what I'm saying is
I'm just referring to what's in the staff report.
Okay, oh, okay,
I'm just referring to what's attached to the staff report.
okay. All right, since,
But we did receive one though. Like we discussed at this push.
all right, Ms. Lambert reported that there were no objections letters that had been submitted by adjacent property owners. Subsequently, we did receive a letter of objection, and so we want to let you know that we did receive a letter of objection to this. And each of the board members have received a copy of the letter of objection. All right. With that being stated, would the applicant and representative please come forward? Good afternoon. Please state your name and your address.
Good afternoon. Antonina Scariano, 265 Magnolia Street, Mandeville, 70448.
All right. Are you going to be representing the case today?
Yes.
All right. Well, you've got 5 minutes, ma'am.
Okay, so we were approved on a pool house guest home, but then my father fell ill mentally and physically, and we recently started taking care of him because he's not able to. So we wanted to convert the back to have a place for him to stay so he can be close but not inside our home because we don't have enough room, obviously. We have 3 kids and 5 people living in our home, so it's just not going to work.
Okay. And any other comments about the construction or anything about?
Do you want to say anything?
I mean, as far as the construction is concerned, we were granted, I want to say about a year ago, to be able to finish it. In the meantime, it hasn't been finished for the mere fact we've kind of been chasing him around the U.S., figure out where he is because he's mentally ill. Once we finally got him and found out there was a situation, finished dealing with a bunch of court and mental hospitals, he's finally here. He's currently living in the property right next door, in which I own. Maybe 6 to 8 months ago, I think we were trying to build a breezeway in which we was granted the breezeway, but then FEMA's code stated that we needed to lift it 6 feet because of the new flood plan. So currently he is there, but we're in the process of getting the permit to get it all done, which this is going to be a pretty extensive renovation for that property, considering the fact that it's 100 years old this year. It's going to be a lot of changes, if not, hopefully not a tear down. And so in the meantime, he definitely needs to be close to us, and she gives him medication, feeds him every day. He's better to the point where he is self-sufficient for the most part, but we'd like for him to be self-sufficient on our property, so there are no hiccups with mental illness that is out of our control that we can't alleviate, right then and there.
All right, sir, thank you. All right, are there any people in the, that are representing the opposite side today are present? All right, sir. Would you please come forward, state your name? And his position.
In opposition.
Yeah, in opposition, correct, sir? Was that correct?
Opposition and more information.
All right, sir.
I tried to do my homework. I reviewed the meeting agendas of this board of, what's it called?
Adjustments. Yes, sir.
Dating back to 1922.
Wow.
Month by month. I called the people at the parish office, and I spoke to other individuals at the parish office. I'm not a contractor. I'm a retired physician. I served at St. Tammany Hospital for over 30 years. My research leads me to believe that we're putting the cart before the horse. That in that there are no details about the guest house, but we're making provisions for a setback reduction before we know what it is that's going to be built. I mean, it's just my way of thinking that it sounds bad. I know from what my research led me to believe, a guest house in a single-family residential A1 district can be no more than 1,000 square feet. I measured the bedroom in my home where my wife and I live. We have 2 full beds and furniture on all 3 walls. This is not counting the bathroom or the closet. But our bedroom measures 15 by 15, which is 225 square feet. So I figured it out that if you put 3 bedrooms in there, you would still have 325 square feet for other entities that I think I'm told are required in a guest house, such as a kitchen, a living area, a bathroom, and hookup. What I said at the beginning, I'm sort of getting ahead of the presentation because this is just for setback. I assume this does not mean that after this meeting, if it's approved, then the guest house is approved without any plans as to the new structure, as to the existing structure, which is a 2-story structure that sits above any roof line in that area. I have other objections regarding safety and traffic, but like I say, it's probably premature because this meeting is only about setbacks, I understand. So, I mean, if you'd like any other reasoning from me,
No, sir.
I'd be happy to give it to you.
Thank
That's it?
you.
Thank you.
Yes, sir. All right. Seeing that there's no one else here that wants to comment on this, I will open it to the.
Oh, she want a rebuttal.
I'm sorry.
Do they want to address those concerns or rebuttal?
Oh, I'm sorry. Would you like to rebuttal his concern, sir? I apologize. I should have given you that.
Sir, sorry, I really don't mean to ruffle any feathers if you are
sir.
opposed to us.
No,
Oh,
sir.
okay.
You have to
Oh, I
address
have to address
us.
y'all. Okay. I don't want to ruffle his feathers or anyone in the neighborhood for the mere fact of I know he probably sees it as, oh, he just doesn't know what's going on, but now he does. And we were already approved for it. We're going according to code. I'm a remodeling contractor, and I actually work for a full contractor who's licensed in several states. It's not something where we're going to put anyone's life in danger as far as traffic's concerned. I'm not totally sure what he means by that, but we're, one house off the corner. I don't know how it's going to obstruct traffic with a house that's already actually there. That the building was already approved. We're not doing anything different from what was approved except for allowing him to live, essentially just live there. What's that? On the first floor. Yeah, well, it's already stated in the original. And the top is attic, the storage area. Because that was, the place that was there originally was a storage, it was a shed. The shed was 80 years old. We essentially just built that, redid that, and had a little space area because we were also approved for a pool, a 10-foot fence, I believe, on the back side and 6 foot in the front. And we got approved, and in the process of doing that, that's when we stopped to deal with her father, who's mentally ill. So we're just going back into it and just making sure that he can be there in the back.
You will have to come back to the permits office to submit revised plans.
100%.
Thank you.
All right, sir.
Thank you.
Thank you. Okay.
He gets a vote. I'm sorry? He gets a vote. The other,
Oh. Do you have anything additional to say, sir? Because this will be your last chance.
He was not speaking into the mic. I didn't hear what.
He was addressing the board, and we did hear
Oh,
what he
okay.
had to
I'm not
say.
supposed to be
But you are welcome to, no, sir, you're more than welcome to come up and address anything else. What he basically stated was that the parish had granted him permission to build the building, had the permit. He had also been approved for a swimming pool, but based on his wife's, based on her mother, it was father, I'm sorry, father, that they had to change their plans, and now they're actually just going to continue to build the approved accessory building that the,
So it won't be a guest room, because that's what I understood this was
I think,
intended for.
yes, sir.
And the guest room has certain requirements.
The Board of Adjustments will have, the board members, sir, sir?
Okay, all right, the board will ask the questions.
I'm sorry.
So we can, no, sir, don't apologize. That's what you're here for. We appreciate you being here.
I'm in a strange environment, I'm sorry.
We feel the same way every time we have a case, because all are very unique and important. So with that being said, I would like to open up to the board a time for questions. Mr. Swindell.
I don't have any questions, but I just want to say, Ms. Scariano, so since the structure was already approved as an accessory building, like, it's going to be built anyway. I mean, I actually appreciate the fact that you've gone for permits to retrofit this building into something that you want to turn as a residential, because I suspect that a lot of individuals in this parish would just do that on the sly and not actually go for permits. And I'll be honest, like, I mean, regardless of the circumstance, I don't really have an issue with it, and especially like since you own the property next door, that's really the one that's more concerned with that side of the property, and obviously you issued a letter of no objection, so I'll be voting for it. I will point out though that we did receive some information that's in objection to what you're doing. So you have some things to work out with one of your neighbors, whoever submitted that information. A lot of that is not really relevant to this one particular request, which is about, setback for an additional guest room. So I'll vote for this when it comes to a vote here.
Yeah, and I do want the board to understand that the request is for the rear yard setbacks and the side yard setbacks. Other questions from the board, please?
Okay, I guess from the applicant, I'd like to know, there was made reference to this exceeds a 1,000 square foot maximum for an accessory building. Can you address that for us? And in other words, and also I'd like to know what it is, because I don't have prior knowledge of the approval. Can you give us what the approval was prior to this case coming forward? Yes, please.
Yes, sir, please.
So the original approval was for essentially like a pool house. It was supposed to be for the kids. That's where the kids go into. It can be set up like your average apartment minus a kitchen, and the upstairs being the storage area, because again, this was originally my storage shed. And we decided to allow the kids, if we did the swimming pool, to have that area, and then the storage will all be upstairs. So all we're doing now is saying, kids, sorry, you can't have a pool house, but grandpa can have a place to live.
Okay. And then, so in that approval, it was approved as a pool house?
Correct.
Minus any sort of kitchen?
Correct.
requirement? In other words, you could allow a
Correct.
hot plate, so, and
Correct.
then also, sewage for bath and
Correct.
water, correct?
There is some plumbing already there currently, because it was, before we moved in, it was a shed that's where the water pump for the well pump's actually inside, and also had the washer and dryer inside of the place.
Okay.
So that was already there. All we did was took all the 80-year-old stuff off. We put new footings in to where it would actually withstand whatever weight for the second story. It was all approved with the company, and that's where we stopped.
Okay.
And at that point, we had to get further approval for anything else.
Okay, and again, just asking about the square footage, because we were made aware that it may exceed the 1,000 square feet. What is the total
Well,
square footage there?
For the bottom portion, I want to say it's 936 square feet.
Okay.
And then upstairs is 936 square foot.
So we're talking about 1,800 square foot total.
1,800 square foot total. But
That's,
and it's the same thing for the pool house. It could not exceed 1,000 square foot, in which they approved, because as long as the upstairs could stay storage, then we could actually keep the bottom the way it was. So I guess it's ruling it as a whole still, but as long as the pool house was only on the bottom portion, not on the top portion.
Right.
The living quarter is limited to 1,000 square feet.
right, I understand, okay.
So you're saying that the bottom level is where the father is going to live?
Correct.
The grandfather's going to
Correct.
live?
There's no way he can make it up the stairs.
And the
period.
the upstairs will remain storage?
Correct.
Okay.
Okay. All right, that's all I've got, thank you.
Okay.
All right, Mr. Glockner?
Yes, my question is to staff. So the approval on the permit was for an accessory building. What is the maximum square footage for the accessory building that was approved? So they're within the limits of the accessory building that they got approved for, correct?
It shouldn't exceed 7.5% of the total square footage or acreage of the property.
Okay. All right. That's all I need to know. Thank you.
All right. Are there any other questions from the board? Do I have a motion? I need a motion stated, please.
I move that the applicant's
Variance.
variance be accepted as read.
So this is to reduce the rear yard setback from 25 feet to 5 feet, and the side yard setback from 7.5 feet to 5 feet. And this is a motion from Mr. Sanders.
Yes.
Do I hear a second?
I'll second that.
Second from Mrs. Swindell.
So it's been moved and seconded that the request by the applicant to reduce rear yard setback and side yard setback to allow for the accessory structure to be remodeled. Okay. I am now going to call for the vote.
We have 4 yeas and 1 nay. Motion carries approved.
I almost did too, but if we're voting on what the variance is. All right, then you have been approved, and you will need to submit another permit to the office prior to continuance. Okay, the next case for today is, give me half a second, 2025-4369, 216 Bristol Place, Slidell, Louisiana, Ward 8, District 9. Representatives are Jonathan and Hillary Glass. The variance requested is a request by an applicant for an after-the-fact variance to reduce the required yard setback from 5 feet to 0.9 feet for an accessory building to remain on the property. I would ask the staff to please read their findings.
The objective of the request is to allow for a 750 square foot accessory structure to remain 0.9 feet from the side property line. While no objection letters have been provided from the abutting property owners, no hardship has been presented to justify the support of the requested after-the-fact variance. Additionally, there is a concern regarding the placement of the structure within an existing utility easement, which may cause a potential conflict for maintenance or repair of the underground utilities. Should the board be in favor of the after-the-fact requested variance, it should be subject to applying for a building permit, submitting a no objection letter from the utility company confirming that the accessory structure can remain within the easement, submit a drainage plan demonstrating that the accessory structure will not cause any adverse drainage effect. Should the board not be in favor of the after-the-fact requested variance, it should be subject to removing the building or applying for a building permit to move the building to a minimum of 5 feet from the side property line. And also, I emailed you a copy of the no objection letter from the HOA.
Yes, thank you. All right, who's representing this case, please? Would you please step forward?
Hello, my name is Andrew Dysart. I'm an attorney over at Tammany, Brinson & Glorioso. Filling in for Mr. Bryan today. He had further meetings and result of his representative gig, but we represent Mr. Glass here today and his board adjustment variance request.
All right, sir. All right.
Yes. I do have some additional packets with some additional information that wasn't fully submitted with his original application that has come to light since the application was originally submitted. So if that be deemed an issue, then we do ask that maybe the board consider us trying again at the next hearing so we have a full record into the thing or into the hearing. So I would like to start by Mr. Glass seeks a variance in this matter so he may attain a building permit to avoid the tear down of his accessory building or to avoid him having to overhaul and move it. The accessory building was reinvented on the property. There was a building that already existed that was dilapidated. It was a boat shed that Mr. Glass, in an effort to clean up his property and make a more functional building, he tore down the old dilapidated shed and added this boat shed. And it's a multi-purpose building for Mr. Glass that really benefits his needs. I want to note that the old building that existed was on a concrete pad. So this concrete pad has existed since Mr. Glass purchased the property. And Mr. Glass has not added on to the concrete pad in any sort of way. He simply took an old building that was erected on the pad and constructed a new one. Mr. Glass has secured, if you'll see in the packet, Mr. Glass has secured, and I'll go through the whole packet if I have the time, letters of no objection from all his adjacent neighbors, the HOA, and his council member, Mr. David Kugel, who has had no objection to this matter as well. Further, we understand there is a concern from the parish that has been made known to us about a teleco easement. Our position on the teleco easement is that that easement is no longer a valid servitude. It's extinguished under the law. So to get to that, before we run out of time, if you flip to Exhibit 4 in the packet that I provided, we had a full-blown opinion done by a real estate attorney who's been an attorney in the area for 15 plus years. And because we couldn't figure out who the owner of the easement was. We tried everything we did. I searched the public record. No direction of who ownership of that easement was for us to possibly obtain a no objection letter from them. Mr. Brinson's findings were the same. He could not find a direct ownership. He reviewed the record himself, the public record himself, and he finds that there's no independent act in the public record that establishes who the owner of the Teleco easement is. The only place in the public record where he was able to establish the easement was in a survey, which backs the letter, and the restrictions that deal with the property. But in neither one of those documents, again, do they show who the exact owner. Teleco was a company that, Teleco Inc. is a company that was, if you search the Secretary of State, like back in '94, they were invented, and nothing has come since then. So if they sold their interest, we just have no idea. So we'd like to make it clear that we've done our very due diligence to obtain a letter of no objection, but however, that's not the case. Further, law says that a predeal to servitude is extinguished by non-use for 10 years. Prescription of non-use begins to run from the date of last use. Mr. Glass has owned the property continuously for over a period of 10 years. The owner of that servitude has never attempted to interrupt his use. Further, the driveway that exists and the concrete slab that the building is on is inside the servitude from the very beginning of the property line. So it's not just the additional piece that the building is in. His entire driveway is constructed through that property easement. So again, the easement we don't think is a relevant issue to this matter. And if that's all my time, I'll stop.
All right. Are there any objections to this case? All right. Then we will open it up to the board for questions. Mr. Swindell.
I don't have any questions. I just want to say I appreciate all the diligence into digging into the easement. I think that's particularly appropriate for what's in front of us. I'm going to make this comment for any future requests that come in front of us. You included a lot of documentation about other non-conforming structures, it appears, in your area. That, as bad as that is, it's not really relevant to what we're charged with, trying to enforce, right? So I'm not really considering any of that information. I do think the information that you guys have presented, just relative to your structure and the easement and everything, is most relevant, and I'll vote to approve.
Thank you.
All right. Mr. Blanche.
Okay, thank you, Madam Chairman. I just have a question for our attorney, and just would like to hear your opinion of this gentleman's conclusions about this servitude having been retired after 10 years of not being used. Are you on board with that? Do you agree with that analysis? Is that something that we should
That
consider?
is a very fact-specific question.
Okay.
So if Department of Planning and Development want
Okay.
that letter, then we would include that.
Okay, so maybe that would be part of a motion to approve that
Yes.
would include a letter that has an opinion from the staff agreeing with this?
Regarding what they would like to see if the variance is approved.
Okay. I mean, quite frankly, I don't have any issue with it, especially with the neighbors being involved and the slab having been there for many years. It is kind of, there is concern with regards to any time that you see some sort of servitude. And that would be my only concern is that it would be verified that there is no issue that comes back to haunt the parish in the future. So that's my comments.
All right. Are there any other comments? All right. I would remind us that as we make a motion, let's turn to the second page where should the board be in favor of the after the fact. Those things should be as part of the motion. And if it is not in favor, then that it should also contain the amendment. So I am open for a motion.
I'll make a motion to approve, but first I don't know, like, he's already done the work. Who does he need to bring that documentation to request? If we include that as part of the conditions of approval, where does that go from here?
I guess maybe we need to, maybe whatever is in the packet, if maybe we'll have to submit what was submitted by the attorney to the legal department for review. And then if there's no objection from our legal department, then, the owner may proceed with,
Contingent upon approval from the league.
the owner may proceed with applying for a building permit unless if you have any other suggestion.
Well, I would have to look more into the facts of the case and see what kind of documents you have, and if there's something else that you can provide in terms of making sure that easement doesn't exist anymore.
But
Because
that-
usually that would be like a declaratory judgment in court, someone finding that fact.
Okay.
So if we see it there, we would need something else to actually prove that it's not there anymore, a finding by a court.
Sure, I totally understand, and I suspect that if y'all were to deny this on the basis of the easement, Mr. Glass would have an appropriate action in the 22nd JDC to declare the easement, non-use. Now, if we need to do that prior to this, y'all know the court process is slow. So he's under pressure from he had 120 days from the last judgment to get this done, or the parish was going to come knock his building down. So if that is a consideration, we absolutely would go through the appropriate legal process to declare the easement prescribed. However, we would just need an extension on that judgment because, trying to get through the court in 120 days wouldn't be valid.
Excuse me, Madam Chair, I'm just wondering if there's another way, another valid way or route to do this, because then we're adding more expense to the applicant, which we're not looking to do that, but we really want to make sure that we are doing the right thing. I'm sure you can appreciate that, so.
Absolutely.
So tearing the building down is going to occur, and then, so I guess what I'm saying is, if what is precluding you from tearing the building down, well, you're right, because of the length of time it could take to get.
Yeah.
Well, you could always make the variance approval subject to getting that documentation so many months. I mean,
Okay.
you can modify it.
Okay.
Agreed. I don't have in the packet, but I would just want to make sure that original judgment against him, that is 120 days, would get extended as well, or that there would be some sort of agreement in the variance judgment that they wouldn't enforce the previous judgment.
So what we're referring to is that this case was posted by code enforcement, and, the owner came in front of the judge from code enforcement. They were given 120 days to apply for a permit or tear down the building. So now, if the Board of Adjustments asks for additional information and it cannot be provided or concluded, within the time allowed, then, the property will be reposted. And if necessary, you'll have to come back to court and, either explain yourself to the judge, or you can request an extension to be able to provide that information.
Does this board, I'm just asking legal now, does this board have the authority to grant that extension?
No.
No.
Okay, so we either give it a yes or a thumbs up or thumbs
But
down
we
at this
could
point?
modify it with a condition, and he could have that ready to bring to the hearing officer.
Okay, I understand now.
Okay.
But it's being worked on,
Okay.
but they couldn't be worked on within that.
How would we go about getting a new hearing?
So in the event that that there's no action taken within the allowed time, until the date that you have to do it, then the property will be reposted by the code enforcement and the process starts again. So at this point, then you can submit a request for an extension and ask to be given more time, considering that you have to provide a document.
Understood. Thank you.
Madam Chair, since there's already a motion on the board, can I make a second motion? That we vote on?
That one hadn't been seconded.
We haven't had, there,
My
it has
suggestion
not
is
been
a
seconded.
postponement. Would that help?
It's not, well, it's not necessarily going to
Because you still have
help.
the clock running on the
Because the time's clicking for
Yeah.
him, so we don't want to incur any additional expense for him. So,
So maybe we can suggest for item number 2, if the wish of the board is to make a motion in favor of the request, would be to have the legal department review the information that has been submitted.
Or actually subject to them providing a declaratory judgment stating that there is no easement.
or subject to.
Because that's really going to be a fact finder, not so much for the legal department to find, but their responsibility to show that that easement no longer exists.
Okay.
Okay, so how do we state that in a way that,
We're just subject to the
Subject to-
conditions of the staff report, except for a letter from the utility company, something from the court showing that that particular easement has been extinguished, and then maybe giving the applicant, 8 months or whatever month, enough time to go through the court system to get that judgment.
But this will prevent him from, he's going to end up going back to court. So this is,
But he can tell the hearing officer at that point that we approve the variance subject to this, so that he should get an extension from code enforcement.
okay, but we're not going to grant any time allowable to do that. It's,
Okay.
so it's subject to submitting a letter of no objection from the utility company
To make it approved
and,
based upon the approval of the
and/or the
A judgment showing that easement has been extinguished.
judgment
That's fine.
stating that the easement has been extinguished.
Mhm.
Okay, so I can read, so Mr. Swindell, did you still wanted to make a motion?
I'm ready.
Okay, so it,
I will make a
Mr.
motion to approve the variance as requested, subject to the conditions from the staff. However, with respect to the letter of no objection from the utility company, if that cannot be obtained, then they must provide a summary judgment from the court acknowledging that the easement is no longer valid.
do I hear a second?
I'd like to second that one. That was
I think I'd like to third that one.
and also subject to the applying for a building permit and submitting a drainage plan?
Yes, ma'am.
Okay, so we have a motion by Mr. Swindell and a second by Mr. Blosh.
All right, would you please vote?
Motion carries, all in favor.
awesome. There you go.
We wish you good luck, and
I just want you to know he left us with an impossible task. This is going to end up in court, unfortunately. But I appreciate y'all's effort to make it work for us.
Yeah. There you go.
Thank you very much. Appreciate
All
your
right.
time.
that one was complicated.
Yeah.
Because, he's,
Well, here's the thing. If we give them approval, they never stop that judgment. So we've given them approval.
which should,
And it's contingent upon him getting that done. So that's
Right.
just needs to take-
but if he, I think what he was saying is if they have to go back to court and the court docket is backed up 6 to 8 months,
Yeah.
and then that 120 days is extinguished, but then he can go in and request, based on our approval, he can go in to the code people and
I'm counting those
request
people being reasonable.
a continuance. That's what I thought we were saying, but I wasn't, clarification.
And that's all he needs to do is go, and then he would have to go back for code enforcement.
Yeah. I think he's a young lawyer. What would that? So, very, extremely. So I think that they handled it beautifully. That was complicated and it was well done. I appreciate the board and I appreciate your motion, Mr. Swindell. I'm not sure I could have said all that.
Yeah, thank you for adding another alternative to it.
All right. Very well. All right, I'm going to ask, is there any old business? Seeing none, is there any new business?
Everyone's got their,
All right, when is our next?
apologies for getting late to the board.
That's all right, Mr. Horn. We understand sometimes that happens.
The next meeting is going to be on a Monday, which is November 10th at 2 p.m.
What? Oh, it's your, well, that was a quick divorce. Carrie must have really been blindsided by that one. Sort of like Nicole and Keith there.
Do we have a motion to adjourn?
Do I have a motion to adjourn? Do I have a motion to adjourn?
Motion to adjourn.
Seconded by?
Second.
Thank you.
All right, thank you all. Meeting adjourned.